Fixing housing 401k plan versus Erica Ward.
Good afternoon, Your Honor. Steve Ellerly on behalf of Plaintiff Fixing Housing. Okay.
Donato, appearing on behalf of Eric and Aaron Ward, the tenants on the lease.
All right. I'm almost afraid to ask, where are we?
Your Honor, I believe procedurally we're at this would be the first pretrial hearing because the first hearing was adjourned because Ms. Toth was out of town.
Yes.
Well, I didn't sign the order, but it was adjourned. However you want to look at it. Yes, procedural. Go ahead.
Your Honor, tenants Erica and Aaron Ward own and operate a horse boarding farm on the property. Under the lease, tenants are required to pay base rent of $5,500 per month without any deduction or set off whatsoever, and that's paragraph 3 of the lease. Tenants, what really kickstarted this dispute, tenants set off $2,800 from the June 2025 rent when they unilaterally placed the hot water tank on the property in violation of the lease. Tenants have not paid rent since August of 2025. From my knowledge, tenants are supposedly placing the rent in their attorney-client escrow fund. They're paying contractors and for supplies with the rent money owed to landlord. Tenants are operating their commercial horse farm rent-free on the property during the pendency of their circuit court action. Tenants admit to withholding rent, so there's really no factual dispute here. Under the lease, paragraph 19A(c), the lease allows landlord to terminate and recover possession of property. Right now, I believe the base rent owed is $24,800.
24/8.
Yes, $24,800. Or if you want me to get into the procedural history, because there is a circuit court action that was filed.
Well, I was just going to ask about that. But I'll get back to you. Let me just. What about the circuit court action?
Your
Is
Honor,
it between the same parties?
it's between the same parties with an added party, Willow Ward Equestrian, which is the business that operates on the property.
Got it.
That is the horse boarding farm that the tenants own. So in June 13th, on June.
Can I just ask?
Yes, sir.
What is the general subject matter of that circuit court action?
The general subject matter is they filed the complaint and they're alleging that landlord, my clients, didn't make certain repairs on the property, and we dispute, the obligation under the lease agreement. But they're still not paying rent, and under the lease, it has that without any deduction or set off whatsoever. So they brought these claims. It was a race to the court, and tenants filed a circuit court action. And then we were forced to answer and counterclaim for breach of the lease agreement, breach of the guarantee, and we brought a tortious interference claim because tenants have been preventing my client from selling the property. My client's been trying to sell the property, and given their operation on the property, that's been an issue.
Who is that case before?
That case is before. I apologize.
Judge outside.
Judge outside has it?
Judge outside.
Okay.
That's correct. Yeah.
All right.
So after landlord filed its answer and counterclaim, we filed a motion to compel payment of rent in August, but the court's earliest scheduling date for that was last week. So we've gone all of this time where tenants are operating on the property rent-free, and my client has his own financial obligations that he's not being paid for but they're still operating on the property. And just because they filed a circuit court action does not insulate the tenants from defaults under the lease, and also doesn't bar this court from exercising jurisdiction over a summary proceeding.
So, Donna Tope here. You do have hearing, that sometimes I'm not able to, hear quite well. So I would appreciate that. Your Honor, I know that you are a very, thorough judge, and I, filed an answer to plaintiff's complaint to recover possession of the property. Thank you very much. And, in that answer, I listed out the situation that led to our filing a breach of lease complaint in the circuit court that is being heard by Judge Alzai. In my answer, I stated that the defendants leased the property at 2801 West Delphi in Scioto Township, Ann Arbor, Michigan. The lease began May 1st, 2021 and ends May 1st, 2028. The property has, and it states so in the lease, has been used as a horse farm. It's zoned agricultural for over 25 years. It has had an indoor arena, showing arena. It's a showing boarding facility. When Fixing Housing purchased the property on a land contract from the former owners, the lease with the wards continued that operation, that it operated as a horse farm. So this is a little different than most landlord-tenant cases, Your Honor, because while Aaron and Erica Ward are the tenants, the place needs to be made healthy, safe for the welfare of not only the residents and the people who board their horses there, but also their horses. They have over 35 horses. So those are the beneficiaries of the landlord's duty to keep the premises under safe repair. About a year and a half ago, Erica notified the landlord that several of the outdoor sheds that shelter the horses during snow, sleet, the torrential rains we have 24/7 had deteriorated to the point where they fell down. A windstorm blew several of them down. They were no longer sheltering the horses, and the debris left by the destruction of the shelters was unsafe for the horses in the pasture. Erica Ward notified the landlord, asked for repairs. He did not respond. He also then went into the pastures because he has had it on the market. In the lease, it says that that it's invested, and he wanted to be able to show potential buyers and host events at the property, which he has not done. But he was looking for septic fields, and he had a bulldozer enter every pasture and dig with a bulldozer down 2 or 3 feet to see if the property perked for septic fields for development. It did not. He did not repair those. That is unsafe footing for the 35 horses that have to be out in the pasture 24/7, and they need safe footing. What started this current action, she also asked him to repair several other things. But what started this entire action was about June of 2025. the spigot which supplies water for the horses, and they need a lot of water, needed repair. It was leaking and it was going to burst and be unfunctional. She asked him to please make the necessary repairs. He did not make the necessary repairs. Aaron and Erica made the repairs themselves. They also, the hot water heater that provides hot water for the horses to be able to have their poultices for injuries.
But all of this is a result, it was in the circuit court action, right?
Yes, but it's under breach of the lease. And so what started this was that they asked for the hot water heater, which had failed. They asked for the hot water heater to be replaced. It's necessary for the safety of the horses.
But what about the provision that the base rent is going to be paid without deduction?
So that is if they live up to all of his responsibilities.
Is it conditional? That's not what I read.
Well, it is not conditional, but in any contract where one party breaches several.
I have two businesses, in essence, that have entered into a contract. That contract can read various different ways. I mean, you're trying to say that there's a general reading for contract. Maybe if it weren't two businesses operating at arm's length, you might be correct, but that's not what I have.
No, we have a lease, and under Michigan landlord tenant law, which I have researched with the Michigan State University Law School and the University of Michigan, the city of Ann Arbor.
MSU Law School? They
They
have one? No, I'm kidding.
they
Go ahead.
absorbed.
It's just my dig at MSU.
Okay, well, they do have one, and they give really great advice to their student tenants. And one of them is that if necessary repairs that affect the habitability, the safety, the welfare of the residents who are under that umbrella.
Where is that base rent?
So in June, they notified him to please repair the hot water heater. He did not. They repaired it themselves. They withheld the cost of the hot water heater. Aaron did the labor installation himself. They paid him the difference between that withheld for necessary repairs that the landlord is duty bound to provide under the lease, and gave it to him.
That's June.
That's June.
Okay, what happened in July, and where's that rent?
Yep, they paid it.
August.
We started withholding in August 1st. In July.
So, all right. No, not really.
No.
You
Okay.
ever do that to me again, you'll be out in the hallway.
Thank you. I apologize. I was not trying to.
August, September, October, where is the base rent?
The tenants told the landlord that they were going to have these things repaired, and that they were going to withhold the rent to make the repairs.
Why can't I just get an answer to my question?
And after they notified him, he had threatened to take over the farm, insert his own manager, and they paid the rent into an escrow fund, out of which the necessary repairs were made. They withheld the rent to make the payments to the contractors that were filling the dangerous holes in the pastures.
Where, out of what account?
They paid the account into an escrow fund that I held for them to be able to pay the contractors for the necessary repairs.
Counsel, like the last case you were here on, now we have a problem. Because either you're going to be a witness or you're going to be a party to this. We ran into this the last time you had a case before me.
Your Honor, I was their attorney, and this was the only way to be able to get the repairs done that had been necessary and posing danger to the horses, the residents.
You're playing, it's one thing if the attorney is using their trust account to hold funds of their client. Right?
Yes,
These were not client funds.
yes. They were the client funds that were to be used to make the repairs for the lease.
Counsel,
In my answer, I have asked that you escrow, the rent was paid with a minor amount withholding that was still a balance due on repairs. The rent was paid this past month, and in my answer, I have asked you to set up, I've asked you to stay the eviction. I've asked you to escrow the rent under the same way you did in our other case. And I've asked you to transfer the case to the circuit court.
not happening.
Your Honor, their notice for possession and eviction is exactly the counter complaint that they made to Judge Alzai several months
That's
ago.
because you filed there.
I understand, but it's the same for judicial efficiency.
Too late.
It's the same circumstances. It's the same claims. It's the
It
same.
may very well be, but that's for the court to decide.
Okay.
And I'm declining to do what you're asking regarding this case
Uh,
at this time.
You mean to transfer it?
I want to know where the escrow is.
The escrow is in my, it's all paid out. The escrow funds are all paid out to the contractors. They paid this month's
Counsel, do you
rent.
see the problem here? Do you?
Well, I know you want me to see the problem, but
Then that must be the answer is no.
no.
You took client money in
I withheld
then-
rent.
and then dispersed it.
I withheld rent under the landlord tenant.
But you can't on your own then disperse it.
They
If
dispersed.
they,
Erica Ward signed those contracts and paid those
Ms.
contractors.
Toth, if as a tenant, they elect to set up an escrow account to put their rent into,
show me the authority that then permits them or their agent to disperse those funds.
This was not.
Show me authority for that. Because I'm going to tell you, you're not going to find it.
My first request was that you stay the possession,
This case.
repossession. In this-
denied. Next request.
motion for you to set up an account for the rent to be escrowed into and paid out.
I am not going to have a problem ordering escrow.
Okay,
What I am going to have a problem with is that I think because of what you just explained to me, that you are a necessary party that has to be joined. Because if they set up their escrow account with you,
no, they paid the rent to me. I did not really, there's no formal escrow account. I held it so she could pay.
Then that's another problem.
Oh, my goodness.
Yes, oh my goodness, because the law has to be followed. They can't just give the rent to somebody else. If they're going to properly withhold, and I would have hoped you would have informed them of this, they have to set up an escrow account. Outside of the fact, then, they are really obligated to then let the landlord know where that escrow is.
I
That
did.
they are. But then they can't disperse it.
How can they pay for the necessary repairs that he did not perform over a year and a
You
half?
file suit and get an order. And the fact that you're a party to that, I think is going to make you a party to this action, because if that money doesn't appear, I think, I'm not suggesting that it occur, but I think plaintiff has a claim as to you, because you had to take that rent as an attorney, as an agent, whatever. You took that in trust. It's like if they had decided to withhold rent and they went like most people would, if they're going to do this, they go to a bank, they set up the escrow account. The bank can't then, if it's set up as a true escrow account, they have to direct that it's paid out. But that's not what's happening here.
Under landlord-tenant law, tenants are allowed to withhold rent. They don't necessarily have to set up an escrow account. They just have to inform the landlord where the money is, where the money
I
is held.
appreciate you giving me a lesson on
I'm not
law that
giving,
I've been doing. for
I'm not.
40 years.
I read the Michigan state law about tenants and what to do about landlords who do not make necessary repairs for the health, safety, and welfare of their tenants, which in this case includes horses and boarders. I also did file suit. We filed suit in circuit court for breach of lease, for every single breach of lease that the tenant has performed over the last,
Is there anything else?
no,
Because you're not listening to anything I'm telling you.
I am hearing you.
You're not listening.
I am listening, and I'm giving you an answer when you say you file suit, and I tell you that I did. We did file suit. No, do you want anything else from me? Do you have a,
I got a ton of questions, but I never get an answer. So you can have a seat. Anything else in the plate?
Your Honor, I would just say that the withholding of the rent is against the lease agreement, and placing in the attorney's escrow and paying contractors and paying for supplies at Lowe's and Home Depot is completely, it's wrong. And what I put in the motion to compel payment of rent is that the case law, we're disputing, and we filed an answer disputing that, we're on the hook for some of these repairs. But longstanding Michigan common law provides that tenant's duty to pay rent is independent of the landlord's alleged covenant to repair in the commercial context. And that's the Rheum case from the Michigan Supreme Court, and Detroit Marine Terminals is an unpublished.
Yeah, but statutorily that's been changed. So I understand the common law rule.
In the residential context, Your Honor.
I see what you're. Go ahead.
Your Honor, that's all I have, unless you have any questions for plaintiff.
Is there another hearing set before Judge Outside?
yes,
What day?
November 7th,
I believe it's Wednesday, this
Yeah.
upcoming Wednesday.
this coming Wednesday.
The basis for the termination in this case is really breach of their obligation, in a lot of ways, the obligation to pay rent. In this case, I think, as I was trying to point out, as this court views it, additional problems and concerns regarding the use of this money. So what I am going to order, which is also unusual to order these cases, but I will order it, that the defendants are to provide to the court an accounting of the escrow paid into whatever the account was and the disbursement. Yes, Ms. Toe.
Your Honor. In my answer to plaintiff's complaint to recover possession of the property and my motions, eviction motion, motion to transfer case and proposed order proceeding, I explained everything, and I included as the very last page, which was exhibit, I can't read my own writing, B2, and accounting.
Which one was it?
That was defendant's answer to plaintiff's complaint. It was filed on October 24th. They got a copy. The last page of that entire filing is an accounting of expenses paid.
Are the receipts attached?
I don't have, I can get the receipt.
I want the receipts attached. I want a very detailed accounting of what came in,
Yes,
what was paid out.
yes.
I want receipts for all of those transactions.
We have contracts, we have paid receipts. And an explanation of everything that the money went for.
Are you done now?
And the term of the lease under which that expense was made.
Are you now done? Yes. So I want that accounting. I am also going to order, how much is the base monthly rent?
Per month.
Per month. This was November paid to you?
The check was sent.
When? When was the check sent?
The check was paid out of Bank of Ann Arbor's bill payer on the first of the month.
And at this point, you haven't received a check. Give me 55 divided by 4 times 3. Times 3, yes. 41.25. I'm going to order that the defendants are deposed with the court within 7 days. Escrow for November prorated in the amount of $4,125, and then are deposed with the court $5,500 on the first of each month, and that rent ordinarily would be due. How long will it take you to get that detailed accounting to me, Ms. Toe?
I'll have it to you tomorrow, Monday.
You've got a hearing before Judge outside next
Wednesday.
Wednesday.
So I will then adjourn these proceedings. See where that has got to November 21st.
Is that before Thanksgiving? No,
It is.
it is. Is it the Wednesday before Thanksgiving?
Thanksgiving is on the 27th.
Your Honor, I am scheduled to be out of town with my family and a relative in Portland, Oregon,
What days?
from the 20th to December 3rd.
Then fine. Then fine. We'll see you next Friday.
Next Friday.
Yep, the 14th. At what time? 2 p.m. in person. All right, by that time, the escrow, at least the first payment of the escrow should have been paid or some verification of the receipt, and then we will go from there. Thank you.
Thank you, Your Honor.
Thank you. Thank you.
Town Creek Place versus Singrid Melvin. Go ahead.
Good afternoon, Judge. May it please the court, Mark Wasbury on behalf of plaintiff.
Your name?
Sigrid Melvin.
All right. I am almost afraid to ask, where are we?
Well, Judge, a couple things. We have scheduled the contractor to do the glazing in the kitchen next Thursday. So by Wednesday, we need everything cleaned out from that area so he can do his work.
Okay.
There's still some items that need to be addressed on the balcony. I don't know what the inside of the apartment looks like. I believe this is her son with her, helping her on those issues.
You're her son? Okay. No, okay, go ahead.
That's it. We want to get
That's
into
it.
the glazing. We want to see where we're at on the inside, and we want a couple things addressed on the balcony.
Balcony, okay.
Okay, Monday, I got a call from John.
Mrs. Young, is she here with us? Yeah, she was here.
I am here. I am here.
Okay, she
Your
was here
Honor.
the last time, in
Yes.
person.
Yes.
She wouldn't talk to me for the longest time. It was horrible. No, I'm kidding. All right.
I called her back to get an update of what was going on.
Right.
I think you guys been out there Monday after 4. They were gonna take some of her possessions of them in Tupperware. But to put the Tupperware anywhere in the apartment, it would still be in the way. Tuesday, I went out there. Big issue, then taking up the room in the apartment was 3 bookcases of books. With the previous management, we had kind of the same issue because the bookcases were in the hallway. They were taking up room going towards the bedroom and bathroom.
Got it.
At that point, they said it was okay to move them into the living room behind the couch.
The previous management said that.
Yes.
Got it.
We're happy with that. We have a new manager in the building. I went in there, I took out the bookcases, all the books. I had pretty much a pickup truck load with books. She has a lot of books she's
Mhm.
of that. So all that has been done, we've arranged everything. Um,
Okay.
she has,
Okay, who's this person?
Like with the Housing Bureau for Seniors.
Got it. Okay.
I do have pictures, like, they weren't able to make it inside, but she did a great job.
and anyways, I went out there Tuesday, all that cleared out, Wednesday, and over. Rearranged more stuff. When I went out there Tuesday, I did stop in the office and told them what I was doing. And Renee, she was like, just let me know, I need the pictures. Okay, so I did my thing. Thursday, yesterday, I went out there to the apartment center. Went in the office and she was in there. I asked her, have you been up there to get pictures? She said no. So, and at that point, she took me in her office. She gave me some paperwork she wanted my mom to sign to adjourn today's meeting.
This hearing, man.
They weren't in court papers or anything like that, but I'm not declining that. The balcony, we did clear off some of the additional pots that were up there.
Got it.
My point went out there yesterday, I figured we'd go up, take her pictures, and if there was more stuff, more issues, I would know at that time and be able to take care of it. The glazing is really not a problem or an issue. We talked about that yesterday. I'm like, let me know when they're coming. She told me to let her know my counters were cleared up. Basically, anything on the counter or kitchen has to go in.
Let me just stop you there. They're coming on Thursday.
Yes,
Next Thursday.
a week, about six days from today.
Got it. No, they're coming on the 13th.
Yeah.
All right, they're coming on the 13th. Does she, when you do that, does she listen?
What were you gonna say?
I have a piece of paper in my bag where it says, they will come in August 2024 to do that.
Okay, we're gonna get it. We're doing it now. Okay?
I'll be out there on Wednesday. Get the stuff moved. I
And
have questions about that as far as reglazing. They're not actually taking the countertops off, they're just re-laminating.
Correct.
Okay. All right.
That's the difference.
Yes, it is. All right. So
And
go ahead.
then if there's, I know, I was looking at the table and the bench on the patio, and it's like, I told her, it's like, I'll get rid of those and get you a new one for your birthday, but if there's more additional stuff up there, she did come over and take pictures. There is quite a bit of room. So the question was access from the door.
Right.
Balcony. Everything around the table is cleared out. The couches is much better. So the thing about that table is, it's a dining room table.
Got it.
Towards the couch, where she can sit on the couch and eat. On the other side, there's plenty of room, no papers, boxes. If you'd like, you could look at her pictures,
Okay. Hang on just one second.
or if he wants, to see if there's
Yeah.
a nice factory.
Well, and my client would like to, next Thursday, when they've set aside time for the glazing, she would like to go in and look at the inside. That would be a great time to.
I think that would be a great time without disruption.
And then I'm also given a picture, it was taken today, this is the balcony.
I can get anything done, yes.
Okay, so I'll just tell everybody what we're looking at the balcony. There's still off to the left-hand side, there's something hanging. I don't know if those are lights or, well, we're not supposed to have anything hanging.
No,
That's not even a plant.
TV antenna.
Uh,
That's her TV antenna.
Oh.
I thought we had clarified that.
Well, that's different. Some, just to the right of that is a baker's rack and then something hanging.
Oh. Yeah, what are those?
That is, all the way to the left, it's like a cast iron trellis that the plants to go up.
Right, I see that, but then there's something, if you look up at the top of the balcony, it's like there's a hook there or something, and there's something hanging from that. It looks like it might be lights.
Yeah,
Yeah.
that's the Christmas lights. I haven't taken down yet, but
You haven't gotten them down yet.
yeah.
You told me you were gonna take them down. You'll get them down, right?
Well, the hook is very high and I can't reach it, even
Okay.
Okay, but your son's now working with you, so he'll get them down, okay?
Right. No problem, there ain't gonna be no Christmas this year. Christmas lights up and my neighbors, they got the lights up already.
No, don't tell her to, I get everything she's saying, so we just have been determined, okay?
I heard the last few cases go on and on.
May I have the floor for a minute? When I came here the first time, I brought you a bag with nice stuff.
With the mice stuff.
Right.
Yeah, no, I remember. We made sure that stayed out in the hallway.
And the mice are still in my apartment. I found 2 dead ones yesterday.
Okay, so here's,
Nobody's coming to pick up the mice or change it and clean it up.
okay, so
It's been
here's,
5 months.
okay, listen, here's what we're gonna do.
Bye-bye.
Okay, hold on. Remember, there was the issue, okay, of trying to just get through to get some cleanup in the unit. Okay, but now that that process has begun and is happening, then we're going to address the mice issue. Okay? But I want to make sure this first part is done and we get through that. Okay? I promise you.
I've been cleaning the apartment for over 5 months, looking for the mice. When the exterminator comes, he doesn't even bring the tools to catch the mice.
Okay.
And I'm nervous, like, because when I get up, first thing I worry about, am I going to step on it or what?
Ms. Melvin, here's what we're going to do. I want to get that done. I want to get the balcony in its position because remember, your hanging pot only has about 8 more days left.
Yeah, well, it's the end of the season.
I know, but it's got about 8 more days. I let it stay there till December 15th so that you know that hanging pot that has to come down to 15th.
Okay. Oh, what date?
It was the 15th. I gave you to December 15th.
December. Oh.
Yeah. Oh, that's right. No, it's got more time. I did put it in December, didn't I? Oh, no, you got about a month and a half. It could stay there.
Okay.
All right.
thank you.
You're welcome. All right. Pardon?
Countertops are next.
Countertops are next week. Get the light down that's hanging, the lights that are hanging down. Then what I'm going to do is I'm going to adjourn you out a week. Okay? I'm going to adjourn this 1 week. So you'll come back and see me next week. By that point, the glazing will be done, right? The light thing will be down. We'll see what other issues there are left. And then if we have time, we'll talk about the mice, but also the landlord can then look at the unit on Thursday before you guys come in.
They've been coming in and out of the unit without me knowing them or letting them in.
Okay, I presume they have a purpose, but we'll deal with that after we get this first part done. Okay, Ms. Melvin?
Yeah.
Okay, anything else for you?
Yeah, when
Okay.
I went to pay the rent, she wouldn't accept the check. Well, she did accept the check, but then she put it under my door back. And the same thing this time, when I went to pay the rent, and she is my witness that I paid.
It's because of the termination, is that what's happening?
Yes, Judge. And my client said she's gone next Friday. She will go in there Thursday, take pictures, give them to me.
Okay,
Yeah, I appear by Zoom next week.
If you send in the form, I don't think I'm gonna have a problem with it.
Okay, thank you.
All right. Okay, so that's where we're gonna do it. Now, how many months have they not accepted of her rent?
2.
2 months? Okay. Do you still have those 2 months of rent?
Of course.
Okay, so here's what I'm gonna order, because this way, if I order it, it's not a Park Forest issue. You paid the 2 months of rent to them. I'm ordering that the plaintiff accept it. Okay? And that way, that's not a leftover issue that we've got to try to clean up. Fair enough?
Fair enough. Also, my mental and health condition isn't particularly the best, as you can see. I have a blood pressure over 200 every day and 103. So I can't take any more. I've been there since 2000.
Okay, I know. All right, Miss Melvin. Miss Melvin, just listen to me. All right. Ever since you've been coming here, you were really worried about that they were somehow going to kick you out and they were going to do whatever, right? And one thing I told you and I promised you is I wasn't going to let that happen unless it's absolutely necessary. And right now, it hasn't happened. So what I want you to do, we're just working through these things.
Okay.
So what I want you to do is just relax. I'm not going to let anything happen until I say so. And if I have to have something happen, I'm going to explain to you exactly why. Because that's what I've been doing, right? When we go through it.
Yeah.
So I don't want you worried about anything like that right now. You hear me?
Yes.
Okay.
Thank you very much, and God bless you.
And the same to you, Miss Melvin. All right. And we'll see you next week. What time? At 2 p.m. Yes, sir. Yes. We'll do 3. They can appear via Zoom. We can do 3 because I appreciate you and everything you've done for your mom.
I know that's free now, but
All right. Okay, Miss Melvin, take care. Yeah.
Thank you, Your Honor.
Thank you, ma'am. You have a great weekend.
The judge, Mr. Belleville would like to have a little bit of evidence on this. I think that it's just a little bit unclear, so if we could have some testimony.
Mr. Ketley, this is a contested matter. I'm going to need to administer an oath to you at this time. So if you'd unmute yourself, raise your right hand. You do solemnly swear that the testimony you're about to give and the matter now in hearing shall be the truth, the whole truth, and nothing but the truth. So help you God?
I do.
Okay, very well. Ms. Norris?
And Your Honor, we would also note that there was an addendum filed by Mr. Ketley. I guess just to clarify for purposes of length of testimony, is defendants admitting to the addendum or no?
So I think Mr. Belleville will be comfortable admitting that he did have an arrest as alleged in the addendum. And then he would want to inquire regarding the notice, and that's part of the inquiry because he says he did call Mr. Ketley. It may not have been immediately, but he would admit that he did get arrested in that case number. So he would stipulate to that.
Okay, you can question Mr. Ketley at this time, Ms. Norris.
Please state your name and occupation for the record.
Ed Ketley, Deputy Director of 13th Judicial Community Corrections.
And are you familiar with Mr. Belleville?
I am.
And why are you familiar with him?
He was placed on our program back in January of 24, actually.
And have you been supervising him since January of 2024?
Kind of off and on because he was supposed to be transferred to Sedgwick County since he was living over in Sedgwick County.
Okay. And has Mr. Belleville previously had a warrant to show cause before this one?
Yes, I believe so, for roughly the same issues.
And So you filed the warrant in this case, this most recent one?
Yes,
And what are the allegations of the warrant?
that he failed to report to community corrections.
And can you be specific about, I guess, dates and times regarding the failure to report?
Well, because we had the last probation violation hearing, and so then I was trying to reapply to get him to transfer to Sedgwick County. Sedgwick County attempted to contact him, and they just was not able to ever connect with him. He just didn't ever show up.
Okay, so we had a previous warrant to show cause on May 16th of 2025.
Correct.
Did you have contact with him after the May 16, 2025 date?
I did. I met with him. I met with him a few times over in Wichita.
And but then you requested a warrant in September of 2025. What happened between the times that you met with him, and when were those, and the September of 2025 warrant?
Can you restate that question?
Okay, I'll break that down. When did you meet with him after May 16, 2025? You said you met with him a couple times in Wichita.
Correct. I met with him on the May 19th, May 27th. I go to Wichita every other Tuesday in the afternoon.
Okay, so you met with him May 19 and May 27?
Correct. And then I talked to him a couple times through email after that. And then I met with him again in July 1st. And then that was when I put in the transfer. Sedgwick County tried to contact him, and he did not respond.
Okay, so on 7/1, what was your instruction to Mr. or was 7/1 the last time you had contact with Mr. Belleville?
Face-to-face contact, yes.
And at
Because
that point,
I interviewed him. I had to update his risk needs, so I interviewed him while we were sitting in Wichita. And then I let him know that once I get back to El Dorado, I'm going to put all his information in. I'm going to put in his transfer to Sedgwick County again.
okay. And what were your instructions to him at that time?
That whenever they're going to call, and they're going to call from a 660 number. And so he needs to respond, and that way they can get him set up to start reporting there.
Okay. And did you have contact with him after that again?
Not since the last, well, I did he emailed me on 7/30 because there was, well, to be honest with you, there was I believe, Cali County. It's either Cali or Sumner, I can't remember. They had filed a warrant on him because he did not report down there. So when he did actually contact Sedgwick County one time, and they said, you need to contact the Sumner County and get this all worked out. And then he kind of disappeared for a month or two.
Okay. So you had email contact with him on July 30th.
Correct.
And what instruction did you give him at that time, if any?
I told him that he needed to contact Sumner County and get his stuff taken care of down there.
And then
That was through email, by the way.
okay. And so and then what? After he contacts Sumner County, then what's he supposed to do?
I did not give that instructions. I just told him, because I knew that Sedgwick County had denied him, I just told him he needed to contact Sumner County and get that straightened out.
Okay. And was he supposed to report back to you or Sedgwick County?
He was supposed to just go to take Sumner County, get that taken care of. I did not tell him to report to me or Sedgwick after that, because I knew that they had a warrant. That's why I didn't specify.
Who had a warrant?
Sumner.
Okay. So, but he never contacted you again after this July 30 email?
Not until the October 17th.
Which was after he was arrested for this warrant. Is that correct?
I believe so, yes.
Looks like he had first appearance on October 15th on the new warrant. And you said he did contact you on October 17th?
Correct.
And while you were supervising the defendant, how often was he to report? Every 2 weeks, once a week?
Well, when I had him, it's like I said, I only go to Wichita every other week, so it's every 2 weeks.
Okay, so he was, and at least initially, he was reporting every 2 weeks, the 19th, 27th,
Correct.
the 1st. Okay. And then you noted an addendum. What was that for, and why did you make an addendum to the warrant?
Because I received notification that he was arrested. Well, I can't even remember how I think I found it looking through VineLink. I seen where he was arrested again for a new case on September 30th. And I did not know about that. I just found that out probably it was this week, either the 3rd or the 4th when I filed the addendum.
Okay, so you found out that he was arrested on September 30th in Sedgwick County. And you discovered that on your own?
Correct.
And you discovered that on either November 3rd or 4th of this year?
Yes. Yes.
And based on your history with Mr. Belleville's case, what is your recommendation for most appropriate action regarding this defendant and his probation?
This is the second time I tried to get him set up with Sedgwick County, and he just they try to contact him. He'll respond, and then he doesn't show up, and so I don't know what to do with him.
Okay. I was going to say, Judge, I would just object to any kind of hearsay regarding what happened in Sedgwick County without somebody from Sedgwick County being here. So I just want to make sure, like, that Mr. Kelly's talking to stuff he personally knows about and not anything that may or may not have happened in Sedgwick County, since they're not here to testify to that.
Your objection's noted, counsel. Any other questions?
No, Your Honor, no further questions. Thank you, Mr. Ketley.
Favre, questions for Mr. Ketley?
Yes, thank you, Judge. So, Mr. Ketley, I kind of want to go through this timeline. We were here for a probation violation, a warrant to show cause in May. After that, I understand that he met with you in May, twice in person, it sounds like. And it sounds like after that, you had some email exchanges. And then on 7/1, he met with you again, and you informed him that you were going to transfer his probation to Sedgwick County. Is that right?
That's correct.
And then I understand from what you testified that at that point, you never gave him any specific instructions about having to come back and check in with you or having to do anything in regards to reporting to you. Is that right?
That's correct.
And now, despite that, he did check in on 7/30. Is that right? With you?
Yes, with me, yes. Yes.
Okay. And you had told him at that point, go take care of Sumner County because you found out there was a warrant out of Sumner County.
That's correct.
Okay. And do you happen to have any idea when that warrant in Sumner County was issued for his arrest?
When it was, I don't know when it was issued. It was issued roughly for the same issues, but I don't know when it was issued. It was issued before mine. I know that.
Okay. And so, and you said that I wasn't clear on this. You said that you thought that he and Sedgwick County did have contact once, or you thought they did not?
I know that it looks like, well, I know that Janet Vaden spoke with him over email and said he needed to come in, and then he did not.
Okay. So, but okay. So that's your extent. You didn't, to your knowledge, they never hooked up.
Correct.
Okay. So then you tell him, take care of Sumner on 7/30. again, I think you said there's no instructions that you left with him that, like, after you take care of Sumner, come check in with me or check in with Sedgwick, or you never left that kind of instruction with him, right?
That's correct.
Okay. So then, to your knowledge, that's his last instruction. But you still issued a warrant on 9/5. What spurred you to try to, or I guess issue the affidavit that spurred the warrant? What spurred you to issue that affidavit?
That I'd had conversation with Sumner County ISO, and I know that they had not heard from him either.
Okay. So 9/5, you found out he had not had contact. You were speaking to Sumner County. All right. So then you issue this failure to report to you. But let me ask you a question. Which point in there did he fail to follow your instructions to report to you?
I probably, in all actuality, I probably should have been more descriptive on the warrant instead of just he failed to report to community corrections. I should have said he failed to report to Sedgwick County Community Corrections. That's what I should have wrote on the warrant.
Okay. But your testimony is that he tried to, but they told him to take care of Sumner. Is that right?
Yes, the one time, yes. Yes.
Okay. Okay. Now, to your knowledge, did he eventually take care of Sumner?
I believe he has, yes.
Okay, so he's been out of Sumner County. He went bonded out. And after that, did he contact you?
He contacted me, yes, on 10/17.
So after he took care of Sumner, then he recontacted you again.
Correct. 2 months later, yes.
Okay. Okay. And then you said that he picked up this new case you found out on 11/3. Now, when he contacted you let me take a step back. When he contacted you, I think you said 10/17. Did you give him further instructions to keep reporting to you?
Yes. I asked him if he could report to me I asked him if he was still working. I said, can you report to the office next Tuesday, which would have been the 21st. And then I did not hear back from him until 11/3.
11/3. And he contacted you 11/3.
Correct. Said he had just now seen my email.
Has
and I responded.
Mr. Belleville ever told you that he's had phone problems before?
I don't recall that.
Okay. All right. Okay, no further questions.
Ms. Norris, anything further from Mr. Catley?
Just one quick follow-up. Ed, Mr. Favre asked you, or you specifically said you should have been more specific in the warrant and said, I believe that you said defendant failed to report, you should have wrote defendant failed to report to community corrections in Sumner County as directed.
In Sedgwick County, not Sumner, Sedgwick County.
Okay, so you said Sedgwick.
Yes.
I just wanted to clarify because I thought you said Sumner. And I don't think I have anything else. Oh, just one quick question. When he contacted you on November 3, did he mention the whole I got arrested for a new case thing?
No.
Okay. And nothing further. Thank you.
All right. Mr. Favre, there appears to be another matter before the court. You had earlier indicated to the prosecutor and to the court that your client's going to stipulate to what appears to be an additional violation. Would you state specifically what your client is stipulating to?
Judge, he would stipulate that he was arrested, as the addendum notes, that he was arrested on September 30th by Wichita Police Department, and that the allegations are criminal possession of a weapon by a felon and driving while suspended. Those charges are still pending. I don't think he's even had a prelim yet on those, but he would stipulate that he did have that arrest.
And did not report it to his officer?
Well, I wasn't entirely sure about that. It sounds like Mr. Kelly is saying that, but I'd like to inquire Mr. Belleville on that first, if I could.
What are you going to ask him here?
Yes, I'd like to put him on the stand if we could.
Oh,
Call him.
all right.
Yeah.
Belleville, you raise your right hand, please. You do solemnly swear that the testimony you're about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, Your Honor.
You may question the witness, Mr. Favre.
Thank you, Judge. Mr. Belleville, I kind of want to just clarify two of these things that were brought up in Mr. Catley's testimony. It sounds to me like he's saying that you understood on September 1 that you didn't have to contact him anymore because your case was being transferred to Sedgwick. Is that right?
Yes.
Did you get a call from Sedgwick County?
Yes.
When did you get a call from Sedgwick County?
I can look at my phone and tell you the exact date, but I spoke with.
Go ahead.
Go ahead. Okay, I spoke with Janet Vaden, and we set up a time for me to come in there, but I didn't make it in there because she told me I was taken off of a list for the orientation because I still had this. I contacted her and let her know I still had the Sumner thing pending. So I told her I didn't want to come into the orientation and get arrested trying to do the right thing with the Sumner still pending on the warrant.
Okay,
So-
so I just want to be clear on this. You spoke to Sedgwick County, but then you informed them that you found out you had a warrant, or they informed you that you had a warrant?
Okay, well, could you repeat that?
Did you tell them that you had a warrant, or did they tell you that you had a warrant?
Both.
Both.
They said I have Janet said I have a matter in Sumner County I need to she rejected my transfer because my Sumner County issue, and she said get that cleared up and then
Okay.
have
And did
Ed Ketley resubmit the transfer.
okay. So did that happen in July, between July 1 and the end of July when you called Ed? Is that when that conversation with Janet occurred?
I'd have to look at the date on the. I have it all
Mr.
in my phone.
Mr. Ketley has testified that he heard from you again, sounds like voluntarily, at the end of July, and that he also informed you to report to Sumner County and take care of your warrant. Is that what you recall?
Yeah.
Okay. And then it sounds like you did not take care of that warrant right away. It sounds like you weren't picked up on that until later. When were you picked up on that?
At the time of the most recent arrest.
Okay, so when you were arrested in Sedgwick County for the new case.
Yes.
And then after that, you bonded out of Sumner,
Yes.
but you did not tell Mr. Ketley, and this is the part I want to clarify. When you got arrested, how long did it take you to tell Mr. Ketley regarding that new charge?
I figured I thought when I did my first appearance on it, from my bond hearing, my last Zoom appearance when we were all logged in, it was I thought it was already brought to light.
You mean your last, you mean your first appearance in this case?
Yes.
So you thought because it was here in Butler that Mr. Ketley knew about it, you didn't have to tell him?
Yeah, I thought that's what my warrant was for here.
Okay. And then after that, just to tie up the loose ends, you did end up reporting to him after you got back out again, correct?
No, I've just spoken with him through email.
That's what I mean. That's what I mean by a report. You've spoken to him, correct?
Yes.
Okay. Now, are you currently employed, Mr. Belleville?
Yes.
Where do you work at?
Red Guard.
Red Guard. Okay. And what do you do for Red Guard?
Second shift painter. I paint blast rooms, like I guess you could call them bunkers.
Okay. Bunkers. Okay. And so you are a second shift painter. Good job?
Yeah, great job.
Full time?
Yeah.
Okay. And um
Is this related to violations, Mr. Favre?
and Judge, actually, no, it is not. I apologize. I am going outside of that. No further questions for Mr. Belville.
Any questions for Mr. Belville, Ms. Norris?
No, Your Honor, thank you.
All right. Anything further, Mr. Favre?
No, Judge.
All right. Ms. Norris, closing remarks here?
Your Honor, it would appear that the defendant did not basically do as instructed, which was to he did not report where he needed to report. One moment, Your Honor. Sorry, Your Honor. It does appear that he did not appropriately report to Mr. Catley, Sedgwick County or Sumner County to take care of what he needed to take care of. The onus is on the defendant to be in the appropriate place at the appropriate time and to be, reporting to the appropriate person. If he doesn't take care of the warrant in Sumner County, Sedgwick County can't accept him, it sounds like, which it sounds like he understood and also told Sedgwick County that he didn't want to show up and just get arrested. So he didn't show up. And then but he didn't also go to Sumner County and take care of that warrant, which is what caused Mr. Catley to file the warrant in September. And it sounds like he didn't get arrested on the Sumner County warrant until he was arrested on the new Sedgwick County case, which also the new case in Sedgwick County, he never told Mr. Catley that he was arrested for new charges or had law enforcement contact. He just assumed that I guess that probation would know. And Your Honor, this is defendant's second warrant to show cause. He has been on probation in this case since January 16th of 2024. Defendant knows what being on probation involves. But the two show causes in this case include him not reporting like he should. Again, it's his responsibility to get through probation, report, etc. And Your Honor, he's just not doing that. So we would ask the court that he is to find that he has violated, and we would be requesting to give recommendations to the court thereafter.
Very well. Mr. Favre?
Judge, I think that his violations are a little less clear than Ms. Norris paints them. I think that specifically the first set of allegations that was initially filed by Community Corrections, Ms. Norris says the onus is on him. I think that if you're going to request revocation of a person's probation, I think you should state with specificity what you're specifically alleging that they did. And the allegations are that they failed to report to Community Corrections as directed. And the testimony seems to be that between the end of our last probation hearing and when Mr. Kelly released him, he actually did report accurately to Mr. Ketley. It sounds to me like the testimony from Mr. Belville was that he did speak to Sedgwick County after he was instructed to, and was told that he needs to take care of his Sumner County warrant. And then he reached out to Mr. Ketley an additional time, which he didn't have to do at the end of July, to try to report. His actual following of the directions to report, for the most part, was accurate. He actually did. He just didn't take care of his Sumner County warrant, which isn't actually being alleged. And yeah, that Sumner County warrant was a hindrance to him continually reporting, but the whole process of transferring to Sedgwick, having Sedgwick accept him, he was trying to follow that process, and things got in the way of that. I think that the other allegation is a little more clear, which is that he, I think, fairly clearly can be said, did not report within 48 hours his new offense. I think that's pretty accurate now that we've heard his testimony. He did pick up that new offense. He is, like I said, still at the early stages of that. And you heard his testimony that he apparently was under the assumption that Mr. Kelly was aware and that was sufficient. That sounds like a misunderstanding. So I would say that he maybe did violate in that sense, but I don't know that it was I don't know that he was willfully trying to thumb his nose at probation. Let's put it that way.
Very well, Mr. Favre. The court does find that the evidence in this case indicates, by preponderance of the evidence, that the defendant did not comply with his obligation to report to an officer as directed, using the fact that I may have an active warrant and I don't want to be arrested as an excuse not to report to the Sedgwick County officer is not a valid excuse in this court's view. He clearly failed to report as directed. The court finds a violation in that regard, and that is complicated by the fact that he picked up a new offense and had a duty to report it and did not do so. So the court does find violation of the terms and conditions of Brian Belleville's probation. Ms. Norris, you had asked to be heard regarding an appropriate disposition. Your recommendation?
Your Honor, as previously noted, this is defendant's second warrant to show cause in this case. He had previously been before the court in May, where the court did a 12-month extension and did do a 3-day dip in the county jail. Your Honor, defendant has what appears to be 29 days of jail time credit. The underlying sentence in this case, as previously ordered, was 12 months in the Department of Corrections. Your Honor, we would be recommending that the defendant have his probation revoked and that he serve the balance of the underlying sentence. Like I said, this is his second warrant to show cause. Reporting seems to be a problem. This is the second warrant to show cause based predominantly on reporting issues. And obviously there is the new case that apparently is now pending in Sedgwick County. Your Honor, we would be requesting that he serve the underlying sentence. And then I think he still has a probation violation pending in Sumner County. I think he's been arrested on the warrant, but I think that the actual warrant to show cause has not gone to disposition. So based on that, we would be recommending revocation, and the court will need to address additional court-appointed attorney's fees and the bids application fee. It just does not appear that he is a good candidate for probation at this point.
Mr. Favre, your recommendations regarding an appropriate disposition?
Judge, I think that the record shows that Mr. Belleville actually did make many efforts to try to report. I think he definitely did that imperfectly, and having the warrant, I think the evidence, says that he was informed he had a warrant, or he told them. Regardless, I think it's true that he failed to take care of that quickly enough, and that was definitely his mistake. But the fact that he reported after that, after he bonded out, I think shows that he's not a person who's trying to, flout probation. He's trying to be amenable. He's making some mistakes. He also, as noted in the direct, is employed. He has a good job, making decent money for the first time. So he's hoping to keep that employment and be a productive member of society. The new case, I don't know. I can't speak much on it because it's still pending, but I would note that it is a felony for having the gun, but he was just picked up in a driving while suspended. He wasn't involved in any other more serious criminal activity. So I don't know that, it is definitely a crime to have a gun if that's true. And I don't want to make comment on that other than to note that there's no allegation that he was engaged in more serious criminal activity other than having a gun on him. So we'd ask the court to consider giving Mr. Belleville a dip or another sanction that would be slightly more serious, but allow him to maintain his employment. We don't want him to lose his employment, and ask that he be allowed to return to probation now that he has a new date for disposition for Sumner. Then hopefully Sedgwick can process him and get him reporting to them appropriately, and he'll be able to successfully complete his probation.
Very well. This time, the court will address Brian Belville and ask him if he has any statement that he wishes to make in mitigation of punishment here.
Yes, Your Honor. I mean, I've lived majority of my life doing bad things. I do it different now. I don't go out commit crimes no more. I just finally focusing on a change, want better for myself. And yes, there's been a small hiccup in that progress, but at the same time, I'm doing way better than I was before. I mean, I make my attempts to stay in contact. I mean, it's not as consistent as it should have been, maybe, but I don't have a license. I travel as much as I can, mostly on my feet. And the one time I did ride that motorcycle, I was actually on my way to the DMV.
Don't be talking about something that might be pending against you, Mr. Belville.
Okay.
Anything else? Independent of that?
No, Your Honor.
All right. Court has previously found material violations of the terms and conditions of probation in this case. This court can certainly understand the frustration of community corrections and other probation officers that are assigned to supervise an individual who erratically reports or is difficult to contact. The court can certainly understand that frustration, as well as the prosecutor's frustration regarding the length of time that this case has been pending in the Butler County District Court system. But with that said, the court finds itself agreeing on the issue of disposition with Mr. Favre. While a sanction is called for here, there was a certain lack of clarity in not only the allegations that were made on paper against this defendant, but also the specific directions that was given to him by various probation officers during this particular time period. And so the court does find a degree of mitigation in this case, though the court has found that obviously Mr. Belville didn't report as directed. There is some mitigating circumstance here. The court will impose a 2-day dip sanction effective immediately. The court will place Brian Belville in jail for a 48-hour period without release privileges, and then to be reinstated on community corrections for the remainder of the period which the court had extended to earlier, which appears to be, according to the court's notes, until May 16 of 2026. It's the intention of the court to continue him on community corrections through that date. I will note, specifically for the record here, that this court has not ruled upon or contemplated either the validity of the new case in Sedgwick County as a violation of the law. Mr. Belville is entitled to a presumption of innocence on that. Further, there are some proceedings down in Sumner County, but at this point, it doesn't appear that that's necessarily affecting his amenability to probation on the Butler County case. So the court is not considering any action that has or may be issuing from the Sumner County Court either. In other words, it would appear that the community corrections officer, upon review of circumstances, may indeed be empowered and authorized to file additional warrants to show cause based on conviction or some disposition of matters that is pertinent to whether he can successfully continue on this probation or should. Regarding bids in this case, the court will assess an additional $100 bids application fee and an additional $200 in legal fees, finding that Mr. Belville is working full-time, should be able to pay those additional amounts for Mr. Favre's valuable services. So $300 total is added to any previous balance that Mr. Belville has in the case. We'll waive any remainder, which the court has no doubt Mr. Favre will have a billing in excess of the $300 total imposed here. All right, the court's already established its expectation regarding expiration date of the probation, but Mr. Ketley, I want specific direction given. Who does Mr. Belville contact upon his release from jail? In other words, Monday of next week, Mr. Belville, you need to contact someone. Who will that be, Mr. Ketley?
He can contact you. Brian, just call me.
Okay. You know how to contact Mr. Ketley, I presume, Mr. Belville?
Yes, Your Honor.
Okay. And I will order specifically that you make contact with Mr. Ketley at the Community Corrections Office next Monday, which is November the 10th.
Okay.
You don't, the court's going to consider that a serious violation again, Mr. Belville. So make sure you get that done, even if you have to go in person to do it.
Not a problem.
All right, and then I'll place Mr. Belville in the custody of the sheriff's representatives until he can be transferred to the jail to serve his 48 consecutive hours dip sanction in this case. All right, Ms. Norris, anything further at this time on this case?
No, Your Honor, thank you.
Mr. Favre,
No, no, Judge, thank you.
is this your only case on this docket, Mr. Favre?
That's it for me, Judge, yes.
Then I can release you at this time.
Thank you.
That matters in recess. All right, James Watts.
Good afternoon, Your Honor.
Once again, I appear to have Mr. Booker seated. Is this Mr. Booker that you're wanting to address?
That's Mr. Booker, Your Honor. We can take that up right now.
Okay. Court next call, State of Kansas versus Jalen Kawan Booker. It's case number 2023 CR 300009. James Watts appears as defense counsel. Amber Norris on behalf of the state. Mr. Booker from the jail Zoom location. It appears to the court that there are allegations before the court of failing to pay, failing to abide by a no contact restriction in the victim in the case, failing to successfully complete Senate Bill 123 treatment, illegal use of drugs, apparently failing to report law enforcement contact to his supervising ISO. What are your client's intentions regarding these allegations, Mr. Watts?
Your Honor, discuss the matter with my client. Is my understanding that on allegation number 3, he would acknowledge that he had a urine sample that tested positive for alcohol in November of 2024. He would, as to number 4, my client would tell the court that he has in fact been attending Senate Bill 123 treatment, although he would acknowledge he has not attended every case, that he has missed some days on that matter. And as to number 6, he would acknowledge he has failed to make any monthly payments towards this court fees and restitution. Judge, I hesitate to make any stipulations on 1 and 2. Those appear to be outstanding offenses. And given the nature of those, and I've checked the portal, they do not appear to be in the portal. So absent some sort of completion on those, I'm not going to stipulate to either of those. And as to abide by the no contact with his co-defendant, again, for Fifth Amendment reasons, my client's not going to stipulate to failing to abide by the no contact order.
All right. Ms. Norris, the defendant is willing to stipulate to violations 3, kind of, to number 4, and to number 6. Is that sufficient for us to proceed further?
Your Honor, if I could ask Mr. Kelly a quick question.
Do you need to do this privately, or can you do it here on the Zoom meeting?
No, here's fine. Hey, Ed, 25 CR 1129, which does that go to in your?
I believe that's the November 2nd.
Are you sure it's not the number 2?
Let me look. Yes, I'm sorry. It's correct. It's number 2, not number 1.
And Your Honor, I'm okay with proceeding with 3, 4, and 6, but I also would be able to share screen regarding conviction regarding number 2. Records from Sedgwick County.
Okay, is there any objection by the defense?
Assuming the appropriate certified records of Sedgwick County, no.
All right, you may share screen.
Your Honor, I just sent a request to Mandy. Apparently that was not on yet. Okay, looks like maybe now it's on. And Your Honor, this is electronically filed August 5, 25 CR 1129.
August 25.
Record of trial. 2 guilty pleas to aggravated domestic battery. And Your Honor, I also have the complaint from that case, which matches the date, filed June 16, 2025, which matches the date on number 2 in the warrant to show cause.
Pertinence of that information would be what, Ms. Norris?
Your Honor, just to note that the date of the offense matches the date because it's based on the police report case number on number 2.
All right, so
as
noted,
opposed to
Counsel.
the Sedgwick County District Court case number.
All right. We'll accept the share screen information regarding conviction in the Sedgwick County case, 25 CR 1129 of the aggravated domestic battery convictions.
And Your Honor, with that state would be fine with proceeding on the warrant to show cause.
All right, Jalen Booker, you can go ahead and take off the share screen now.
I am. There we go. Thank you.
Jalen Booker, you've been present. You've seen and heard what's been announced. It's the court's understanding that you would stipulate and agree that you had a positive urine test for alcohol in November of 2024, that you haven't attended Senate Bill 123 treatment in full compliance, and that you haven't paid on the case. Do you stipulate and agree to these things?
Yes, Your Honor.
You understand in doing so, you're waiving any due process hearing that you'd otherwise be entitled to, where the state would have the obligation of proving these allegations as they have the one involving the Sedgwick County convictions. Do you understand that?
Yes, Your Honor.
You understand that the court could, among other possible remedies, just consider an outright revocation and ordering you to serve the remaining balance of your sentence in this case locked up in prison.
Yes, Your Honor.
Okay. So do you waive a hearing in this case and stipulate and agree that you committed the violations 3, 4, and 6? In other words, the positive urine test, not attending Senate Bill 123 treatment in full compliance, and then failing to pay?
Yes, Your Honor.
All right. Court finds that the defendant has knowingly waived his right to a hearing and stipulates and agrees that he's committed certain violations as alleged. The court will also find the state's proven by a preponderance of the evidence their allegation in number 2 of the warrant to show cause, which is essentially violations of the law which led to eventual convictions for aggravated domestic battery in Sedgwick County case number 2025 CR 1129. Goes without saying that these are substantial material violations of the terms and conditions of his probation. However, the court does want specific input regarding inappropriate disposition. I will begin with Amber Norris on behalf of the state of Kansas.
Thank you, Your Honor. Defendant has been on probation in this case since September of 2024. And has approximately 75 days of jail time credit accrued over the course of this case. But based on the violations, the state would be requesting that the defendant's probation be revoked and be ordered to serve the balance of the underlying sentence. the underlying sentence in this particular case is 11 months with the Department of Corrections. Your Honor, these are significant violations. The defendant has been given ample time on probation to accomplish probation conditions, has not, and then also has new convictions. So we would be requesting revocation at this time.
Did he receive a prison sentence in the Sedgwick County case running consecutively to this one?
Your Honor, I don't think that.
I saw a September anticipated sentencing date in one of the journal entries.
And I did see that as well. And Your Honor, I don't have the answer to what the sentence was. I'm guessing, I mean, he has been in our jail since 10/6. So I assume that hearing happened, but I just don't know.
Jim, do you know?
I don't, Your Honor, but I presume, given that it's a felony committed while on felony probation, they would have to be consecutive by statute.
All right, Mr. Booker, what was the outcome of your sentencing?
It's my understanding.
I was given probation.
You were?
Yes, sir.
Okay. But then weren't allowed to go on probation because of this Butler County hold.
Yes, sir.
Okay, is there any information before the court to dispute Mr. Booker's statement? Mr. Catley, do you know?
He's placed on community corrections on, I believe, September 24th.
For how long?
Sedgwick County.
If you're able to determine.
Judge, I'm showing 24 months.
Yeah, I believe that's correct.
Thank you. Mr. Watts, what do you recommend here as an appropriate disposition?
Your Honor, this is Mr. Booker's first probation violation. Typically, that would call for a dip. I will be the first to acknowledge, frankly, the circumstances here call for a more significant than a dip. Mr. Booker has picked up new felonies while on probation. That is to Sedgwick County. They've placed him back on probation. So they believe that he is still a valid risk for probation. It appears he was arrested in this case on our warrant, according to what I have in front of me on the show cause warrant on October 6th. So he has been in now approximately 30 days. I'll be blunt, Judge. I think I would recommend the additional time up to a 60-day sanction in this case, and then place him back on probation and see if he could complete this probation and the Sedgwick County probation. He will at that point have an underlying sentence of 11 months in our case, minus whatever he served, plus whatever time was the underlying sentence in the Sedgwick County case. So he's probably looking at, give or take, 3 years of prison sentence. If he fails this case and or the Sedgwick County case, he's going to be in for a significant period of time. So he's got a lot of time hanging over his head. So our recommendation, Your Honor, would be to a significant sanction here, 60 days minus the time he's already served, and then see if he can complete these 2 probations.
Mr. Booker, do you have any statements that you wish to make in mitigation of punishment here?
Yes, Your Honor. I will say that I have had a change of heart, change of mind, and that I can get this done, and I'm determined to get this done. And I promise you,
to get what done?
This all of my probation, everything that I have to do for probation, and everything I need to do to just be a free man again. I'm more than determined to get up from up under the state and be on my own feet again.
Do you even have a place to go live, Mr. Booker?
Yes, I do.
Where at?
I have a place of my own. It's a 2-bedroom apartment and off of Lincoln and Oliver in Wichita.
Okay, you don't have to state it, but I trust you know what the address is.
Yes, sir.
Just so you don't get lost when you go home.
Yeah, no. No, I know my way.
Well, I want to know where you're going. Then I want to know, what would you do with your time? How would you make your own money legally?
Well, before I got arrested, I actually had an overnight job lined up that I was getting ready to start. But with me
You
being
scare me with the term overnight job. What does that mean?
well, it was at a warehouse. You know, I'm a barber throughout the day. I make pretty decent amount of money doing that throughout the day, and I just wanted to add. I was starting that job so that I could, you know, throw some more money into paying off these fines faster. But whenever me and my corrections officer discussed me paying my fines, she tried to walk me through it, but we couldn't find it. So that's why I never got paid. But yeah, I had that job lined up, and I was gonna do that on top of barbering just so I could have a little more money in my pocket. I'm trying to be a good man for my kids as well. So I'm just juggling a lot.
Okay, I appreciate you answering the court's questions the way you have, Mr. Booker. This court has a certain amount of surprise about Mr. Booker's status, looking at the seriousness of the charges in Sedgwick County, and I'm sure that the circumstances of that case and the negotiations on that case all were handled appropriately. But even after conviction for the violations of law over in Sedgwick County, he's been placed on probation there. Perhaps he clearly qualified for a presumptive probation. I don't know, but apparently the facts of the case are that he currently is on probation in Sedgwick County. So the question really is, based on those very same allegations that he was placed on probation for because they were violations of the law in the Butler County case, does he go to prison for it? And this court's answer today, Mr. Booker, will be no. Though this court very well would have legal justification of just saying you're just not going to make it on probation because you went out and committed serious crimes. You apparently have a probation plan in effect in Sedgwick County that might, and I'm saying might, be successful. Whether it's successful or not, Mr. Booker, is to whether you can keep your resolve to stay out of jail and prison. And I understand Mr. Watt's recommendation to this court to really make it hurt as far as jail time and perhaps even give you the maximum amount of time that Kansas law would allow before your probation can be reinstated, which is 60 days. The court's not going to do that either for this reason. That wouldn't count toward a graduated sanctions penalty in this case, Mr. Booker. And I don't even need to explain that. Your lawyer could. So the court's going to impose a 3-day dip at this point because, Mr. Booker, if you come back before this court again because you violated 2 probations, Sedgwick's and ours, I don't know that Sedgwick is going to have any tolerance for that violation, but I'm going to assure you that this court is very seriously going to consider just a prison sanction next time. But I want to give you a chance to be successful. It's up to you to take advantage of that one opportunity that you're going to be given. So the court will impose a 3-day dip sanction that is prospective in nature. That's 3 more days after today. Then on Monday, you're going to be released back onto community corrections in both Sedgwick and Butler County. You will report in Butler until you're officially transferred to Sedgwick, which I see coming down the pike, Mr. Catley.
Yes, sir. He's already been assigned an ISO over in Sedgwick County, Your Honor. I
Okay.
can just contact him.
So I want you to report in one place, and I want you to report successfully, Mr. Booker. So just understanding, from this point on, I'm not going to be that interested in what Sedgwick County does. You need to be in full compliance in your Butler case.
Yes, Your Honor.
All right. I'm going to look at dates here. Is there any need to order a formal extension, Mr. Catley?
I don't believe so, Your Honor. He's not due off until September of next year, so.
Okay. And that will remain his current probation expiration date. Mr. Booker, you've been locked up for so long, the court's inclined to waive any additional bids assessments, though Mr. Watt's services have obviously been valuable, but I'm going to waive those. Anything previously ordered remains to be paid. Okay. Last but not least, Mr. Catley, do you have any further direction to give Mr. Booker when he gets out? Now, I'm presupposing he doesn't have other holds.
I would think so, Your Honor. I don't think he
Okay.
has any other holds.
Okay, about this time Monday, you're going to be getting out, Mr. Booker. I think it's supposed to be really cold that day, so I hope you have a coat.
I wore shorts.
Okay. Well, maybe they can give you something, but maybe there's somebody who can come pick you up from the jail that you can contact. But what would you have him do regarding community corrections? Contact you on Monday or Tuesday? Well, it wouldn't be Tuesday, Monday.
Jalen, I think the best thing for you to do, I believe, is as soon as you get out, go to 905. Or you know where community corrections is in Sedgwick County?
Yes, sir.
Go there.
Okay.
Your ISO is Camille.
Okay.
Ask for Camille.
You have specific direction from your officer. You need to do that, Mr. Booker. Okay.
Yes, sir.
You have any questions about what we've done here, Mr. Booker?
No, Your Honor.
Anything further, Mr. Watts
No, Your Honor, thank you.
or Ms. Norris?
No, Your Honor. Thank you.
Very well. Then the Juwan Booker matter will be in recess at this time. Jalen, I hope you make it.
Thank you, Your Honor. I will.
Okay. We'll see.
That was my last case, Your Honor. Am I free to go?
Okay. I have Christy Ashenfelter on here.
I am, Judge.
Okay. All right. Thank you, Mr. Catley. I appreciate your time.
Excuse me, Judge.
Yes, Mr. Patterson.
Before you move on this case, may I inquire whether Devin Ward is at the courthouse?
Yes, I have Mr. Ward here at the courthouse.
Judge, may I do a breakout room with Mr. Ward while you're doing a case?
Yes.
Thank you.
Mandy, if you can set that up.
And Mandy, that'll be in court security 2.
Okay.
Cody Gerwin.
Yes, Your Honor.
Okay. Ms. Norris. Thank you. This is State of Kansas versus Cody Allen Gerwin, Butler County case number 2024, CR 148. Cody Gerwin appears from the jail's Zoom location. James Watts is defense counsel. Amber Norris appearing on behalf of the state. I'll also let counsel know that I think I have a law enforcement officer who is listed as iPhone on the Zoom meeting, who I think is appearing in connection with that case. This matter comes before the court at this time pursuant to a warrant to show cause alleging probation violation. Listed as a suspect in a criminal damage to property case in El Dorado, failing to report as directed, failing to obtain suitable employment, positive urine sample for meth and amphetamine, failed to attend MRT program, failure to make payments toward his case, failure to attend alcohol and drug treatment as alleged by Ms. Ashenfelter. I'll also note that there is an addendum to original warrant document that's been filed in the case referring to some alleged criminal violation in Sand Springs. Is this Missouri? Oklahoma. Okay. Oh, I see. I see now. Thank you. Sand Springs, Oklahoma. Regarding all of this, Mr. Watts, what are your client's intentions?
Thank you, Your Honor. As to the first allegation of the warrant to show cause, failing to report as directed, my client would acknowledge he failed to report on August 12 of 2025. He did not receive the instruction. I don't doubt that it was sent, but he did not receive the instruction to appear on August 19. So he obviously missed that as well. As to the second allegation, I'm not sure what he's asking to stipulate to. He's not alleged to have violated the law. He's alleged to, I guess, be a suspect. I'm not sure what that means. So he's not going to stipulate to that as a violation. As to number 3, he would acknowledge he'd failed to provide employment or documentation of disability. My client has spoke extensively about trying to get work, and particularly about trying to get disability and not being unable to accomplish that. As to failing to attend MRT, he would acknowledge he failed to attend MRT those 2 dates. He would acknowledge likewise that he failed to make payments towards this case and would acknowledge that he failed to attend the alcohol and drug treatments. Again, as to leaving the state, I've not seen any records, nor do I see any witnesses. It has to do with his Sand Springs Police Department, so he's not going to stipulate to that violation.
I don't see that alleged. Where is that?
Well, that the addendum to the original warrant, Your Honor, fail to obtain travel permit to leave the state. Absent some evidence that he left the state, he's not going to stipulate to that violation.
And actually, Jim, the addendum that I'm looking at, it just basically says failed to notify ISO of law enforcement contact, basically ×3.
Am I looking at-
And then failure to register, or defendants has failed to register and is currently not in compliance.
Okay,
There's two separate addendums.
Oh, okay. Okay, that might.
Okay,
Yeah.
I'm looking at the wrong addendum. I didn't even get to the other addendum with my client. Well, obviously, I'll speak to the same. Given that these are Sand Springs allegations, and given I don't know what the status of those, he's not going to stipulate to any alleged violation of the law in Sand Springs, Oklahoma.
Well, but Jim, it doesn't say violations of the law. It says failed to report to ISO that he had law enforcement contact.
I haven't seen any evidence he has law enforcement contact.
Okay. And then what's the last thing is something about register?
Frank, I didn't speak to my client. I saw the later addendum. I didn't see the first one. I can't, frankly, I can't answer that one. Mr. Gerwin, do you believe you are currently in compliance in your registration?
I do.
No, he would not agree with that allegation.
It looks like you skipped over one, or at least I didn't hear your announcement regarding the positive UA for methamphetamine on the original warrant.
I don't think I missed it, but I don't think I skipped it, but I may have. He would stipulate that he tested positive for methamphetamine and amphetamine.
Okay.
Yes. I'm sorry if I skipped that one.
All right. Ms. Norris, you're now aware of what the defendant is admitting. Do you need to present any additional evidence regarding anything else?
Your Honor, I don't think so. Because if I'm understanding correctly, he's stipulating to 2, 3, 4, 5, 6, and 7 in the original warrant, and basically nothing in either addendum.
That's the impression I have, yes.
I would agree with that. Aside from, I don't think 2 is a violation. The allegation is he's a suspect in the criminal damage to property. I don't know what that means to be a suspect.
Well, and Judge, that's number 2 is August 12, defendant failed to report. Number 1 is defendant was listed as a suspect.
Okay, that's.
Go to the bottom of the page, Jim. 1, 2, 3, 4, 5, 6, 7. You need to look at the actual warrant.
Well, I'm looking for the request for revocation that was supplied. I don't know that I have the actual warrant.
Well,
I'm looking at the warrant to show cause, Mr. Watts, and it appears that you earlier had announced, if we were going to look at numbers, that he was stipulating to 2, 3, 4, 5, 6, and 7.
Okay. Well, I'm looking at the request for revocation.
Okay, well, let's all look at the same document. Why don't you turn to the warrant to show cause itself?
Again, I don't know that I have a copy of the warrant. Hang on a second. Let me pull up eFlex and I'll see if I can find it.
Jim, number 1 is the suspect one, that he's a suspect in a case out of El Dorado Police Department.
Well, I can tell you this, and I'll look it up, but I'm not sure what it means to stipulate you're a suspect. It's not an allegation he's violated the law. It's not even an allegation of police contact. So I'm not sure what it means to stipulate that you may or may not be a suspect.
Well, and Jim, we're just confirming, he's not stipulating to number one, which is the police suspect, correct?
What?
Okay. He has consistently denied, Ms. Norris, that his client will be stipulating to number one. I think that's well established. Let's move on.
Okay, Your Honor, state is not interested in belaboring of the hearing any further. We're okay with proceeding with the stipulations that we have.
Okay. All right. Now I have an officer here. I'm not sure what department he's with, but I want to make sure that if we don't need him, he's released.
Your Honor, he's with El Dorado, and I would say that we don't need him because I would actually tend to agree with Mr. Watts that being a suspect is not a violation of the law as yet. So that one probably just needed to be worded differently, but I think that we don't need Officer McGathy, who is present. So we would ask that he be released.
Officer, I appreciate your patience as we work through this docket. You've had a long wait, and I apologize for that, but I think we can go ahead and release you from this meeting.
Yes,
at this
Your Honor.
time. Okay.
Thank you, Your Honor.
Thank you.
I wonder why those are in different orders.
All right. I think I know where we are. I'll address Mr. Gerwin. Mr. Gerwin, you do have the right to a due process hearing where the state would have the obligation of proving these allegations by a preponderance of the evidence. You can confront the state's witnesses unless good cause was shown. And I also need to point out to you that among other lesser remedies, the court could consider just outright revoking your probation and having you serve the remaining balance of your sentence locked up. Do you understand these things?
I do understand, Your Honor.
Do you waive a formal hearing and stipulate and agree that you committed the violations that your attorney stated that you would stipulate to?
I agree.
Okay, now let's go through those. You are stipulating that you failed to report as directed, you failed to gain and prove employment, you failed to attend all sessions of the MRT program, failed to make payments, failed to attend alcohol and drug treatment, and had a positive UA for methamphetamine. Is that what you're agreeing to?
Yes, Your Honor.
Okay. Court does find that the defendant has knowingly waived his right to a hearing on these particular violations and stipulates and agrees that he committed them, and they are substantial and material violations of the terms and conditions of his probation in the case. We'll now turn to disposition. Ms. Norris, what is your office recommending here for Mr. Gerwin?
Your Honor, this is defendant's, let's see, it looks like first official probation violation. He was originally sentenced on February 19th, 2025. Your Honor, he's previously had a dip sanction from his ISO. It appears that was done in July, and that was for positive amphetamine lab test of urine. And Your Honor, it does appear that this was a presumptive prison case, and the court did basically a departure to probation or made findings to go to probation. Your Honor, at this point, based on the allegations and the previous dip and the fact that this was a presumptive prison case, we would ask the court revoke and remand the defendant to serve the underlying sentence, which in this case is 20 months in the Department of Corrections. And Your Honor, it appears that he's got in the neighborhood of around 120 days of jail time credit as of this date. And the court will need to address additional attorney's fees and the bids application fee.
Mr. Watts, what would your recommendation be regarding an appropriate disposition here?
Well, Judge, Mr. Gerwin's sentenced in February of this year, so he's been now on probation for approximately 9 months. This is, as Ms. Norris noted, the first time he's been before the court on a warrant to show cause, although he has done a dip sanction. What he stipulated to here, and Mr. Gerwin has been very vocal when I've talked to him, both in the original of this case and in the warrant to show cause. He is struggling to get his life back underneath him. He is trying to get disability set up and trying to get employment. Neither of those have been able to be very successful. He acknowledges that he has, as the stipulation are, has not made many payments, hadn't made any payments, but he hadn't had any employment either. By the same problem, he has the same problem with transportation and making alcohol and drug treatments. Judge, I think it's a sanction is appropriate here, and he's already done a dip. He has been in custody now since, now I've looked up the warrant on the eFlex system. It looks like he's arrested October 13, so not quite a month as of today. Judge, I think that the sanction he has been in, plus whatever additional sanction up to 60 days, the court believes is appropriate. But I don't think, given a first-time warrant to show cause, that it is time to basically throw him away and remand him to custody. This is a program he can still do. I won't tell the court it will be easy, and I know with Mr. Gerwin, when he came in and we first talked about this case, he believes that he has not been treated fairly by the system. He may have a basis for that belief. But at this point, that is neither here nor there. This is the program he has to do. This is the treatment program and the probation program he must do. And he needs to take responsibility for the violations here. But given an opportunity to finish that probation, it is not time on a first probation violation to remand him to custody.
Mr. Watts, did I get the impression properly from your presentation that he came to see you in your office in regards to this warrant to show cause?
No, Your Honor.
Oh,
When
okay.
this case first came down,
Oh, okay.
Gerwin was very clear that he did not believe he was treated fairly by law enforcement. And I will tell you, I don't think he believes at this point he's still being treated fairly by law enforcement and the system. And I'll be perfectly blunt, Judge, he may have a basis for that belief. I'm not sure he's treated entirely fairly by the system either. However, at this point, that doesn't matter. At this point, it is, I have to do the probation, and I think he can do this probation. So, Judge, I just urge the court not to revoke him on a first probation violation.
All right. I understand your position, Mr. Watts. First of all, this court wishes to clarify regarding any aspect of the addendum which referred to Sand Springs, Oklahoma malfeasance of any kind. The court is not considering it, considers that excluded from consideration for all purposes, either a finding whether the violations have been committed or any disposition related thereto. The court considers that wholly separate and distinct. The court will consider what this defendant has stipulated to in this case, again, finding that they add up certainly to substantial material violations. And I understand to a certain extent Mr. Watts' arguments here. But with that said, I want to address the defendant, and I want to ask Cody Gerwin, do you have anything you want to say about this?
No, Your Honor.
Okay.
I could get at least in-care treatment or something besides my time. I would be willing to do it.
Okay. This was a case that is not typical in that this court granted a departure sentence in this case. Instead of following the statutory presumption of a prison sentence in this case, this court wanted to give Mr. Gerwin a chance. When there's such a departure sentence and probation granted, there are many requirements put upon a criminal defendant to comply with to avoid this court eventually carrying out that presumptive prison sentence. In other words, the bar is set high for a defendant under these circumstances. And when I look at what has been stipulated to, they are, to this court, fundamental components of the probation: failing to report, failing to get a job and showing that you're self-supporting of some kind, and obviously a legitimate disabled situation the court takes into account, but he's not on disability. There's been no finding from any governmental agency that he's disabled. So the court's not going to rely on that as an excuse not to find some sort of employment. The MRT program is meant to be a rehabilitative program, just as alcohol and drug treatment is. He hasn't done those. And obviously, he hasn't made payments, which the court will not consider that too harshly under these circumstances, because he probably has not had the financial resources to pay, which the court recognizes. But also, the court cannot in any way bless in any way the fact that this defendant went out and got involved with a dangerous street drug, methamphetamine, and ended up being positive on a test after being put on probation and knowing how close he is to a prison sanction. He's still using, despite having no financial resources to pay on his case. Somehow the resources were marshaled to get an illegal drug. Essentially, any of the components of the probation program that were meaningful expectation that things are going to be different in the future. And again, this was a departure case. And even with that said, there was a dip sanction imposed by the officer in this case. In other words, one last chance to try to take corrective action for Mr. Goodwin. And even that hasn't been successful. The court considers this a failed probation case, a departure sentence that simply seems improvident for this court to have granted under the circumstances. This court will order at this time that the probation of Cody Allen Goodwin be revoked outright and having him serve the appropriate sentence in Department of Corrections custody. With that said, this court has discretion under KSA 223716 to consider a lesser sentence. And the court does note that the investment of supervision and rehabilitative resources that usually exists on a revocation to prison case perhaps hasn't been invested as much, which the court considers in mitigation here, and that it is the first time that he's been before the court. The court considers that given the crime of conviction in this case, the offender registration violation that he was eventually convicted of, and possession of drug paraphernalia, the court will modify the sentence in this case to a 10-month sentence, noting that Mr. Goodwin already has served 4 months of that 10, even with no good time credit applied. There is a 20% good time credit, and I will confirm. No, actually, there's a 15% good time credit. I stand corrected. The good time credit percentage would be 15% here with a 24-month post-release supervision period. I would ask the county attorney's office to compute with exactitude the amount of jail time credit days. Indeed, the 120-day figure may be exactly accurate. Can you represent that, Ms. Norris?
Your Honor, I do believe that it is. We got jail time credit from the jail, so I do believe it's 120 days as of today's date.
All right. So the court's orders are outright revocation, defendant to serve a prison sentence, modified to a 10-month overall sentence in the case, 24-month post-release supervision, 15% good time credit. Any additional bids assessments are waived given the court's incarceration sentence. Anything previously owed is still owed. If this is a case that hasn't been set to collection, the court will just set a payment plan in this case that if the defendant somehow can marshal the resources to pay off his case in the next 30 days, there'll be no collection fees added. If it hasn't been sent to collection, at the end of that 30-day period, all become immediately due, payable, and collectible, and referred to the collection agency at that point. All right, with those orders made, Mr. Watts, are you aware of anything further that needs to be addressed here?
Only one thing, Judge, and it may be a meaningless point, it may be moot. We've spoke this afternoon of this being a departure case. My notes and the journal entry do not reflect that. This is a case where Your Honor denied the departure, but made essentially a border box finding. that the non-prison sanction would serve community safety interests. He fell in a category where that was possible. Although I note the journal entry doesn't actually have that checked, but neither does it have a basis for a departure checked.
Your Honor, the PSI specifically says that he is presumptive prison based on special rule.
It does, and it also notes that PSI also includes that that special rule placed him in a position where he could get a non-prison sanction if the court made appropriate findings, and the court did that, finds that community safety interests were served. And so I don't know that it's a difference that makes a difference, that it's a finding of community safety interest, essentially a border box or a border box type finding rather than a formal departure. But I just want to note for the record, there was a difference there.
It's an important distinction, Mr. Watts. I'm just looking at the sentencing journal entry.
And I think that some of the sentencing journal entry that things that should have been checked were not necessarily.
Yeah.
Had there not been a previous dip sanction in this case, I think Mr. Watts' point may have legal pertinence. The court corrects the record. It does not appear that this was actually, his probation was not actually as a result of a departure sentence based on substantial and compelling reasons, but rather based on certain findings that the court made to impose a non-prison sanction. However, the court's evaluation of Mr. Gerwin's lack of progress on probation remains unchanged. The court will note for the record again that there was a dip sanction previous to this as a progressive sanction that was tried in this case and failed to correct his behavior. It is still a case for outright revocation in the view of the court. And the court's prior rulings and orders stand. But thank you for that clarification, Mr. Watts. All right. Ms. Norris, anything further we need to address here?
No, Your Honor, thank you.
I would just suggest to Mr. Gerwin that if he's in Department of Corrections custody for a few months, he takes advantage of any corrective or rehabilitative program that they might offer so that he's in the best chance to succeed when he gets out. The court will remand his custody to the Butler County Sheriff's Office until Gerwin's custody can be transferred to the Department of Corrections to serve the remaining balance of the 10-month prison sentence imposed here today. If there's nothing further, the Cody Gerwin matter will be in recess. We'll move on to another matter. Mr. Patterson?
Yes, Your Honor.
At this time, the court will call State of Kansas versus Devin Michael Ward, case number 2024 CR 452. Amber Norris appearing for the State of Kansas. James Watts as defense counsel. Devin Ward appearing from the court security Zoom location located at the Butler County Judicial Center.
Actually, Judge, I think that's Mr. Patterson's case, and I believe that's the last one I have, if I may withdraw.
You may, Mr. Watts. Did I announce Mr. Watts as his attorney?
You announced Mr. Watts. Yeah.
Aaron Patterson.
Sadly leave, but yeah. Okay.
This has generally been a Watts docket, largely, so.
Have a good weekend, Your Honor.
You too, Mr. Watts. You're free to go. Court will review the sentencing notes in this case. Mr. Paul was his attorney at that time. At that time, the defendant pled no contest to an amended count 1 misdemeanor theft, a Class A misdemeanor, received a 12 months jail sentence, 12 months reporting probation with court services, standard conditions, and other conditions imposed. And that order was made on April 4 of 2025. Subsequent to that, a warrant to show cause was filed by Kelsey Moore, court services officer, alleging failure to pay, failing to submit to random but reasonable breath, blood, and urinalysis testing at the request of the CSO. Court is also familiar with the allegations regarding the facts which stem from that particular violation. The factual basis for that particular allegation was failure to submit a UA. Mr. Ward was asked for a UA at his scheduled appointment on 9/24/2025. He stated he needed water. He was instructed to get a drink from the water fountain and return to the lobby of court services. Mr. Ward was then observed by courthouse staff running west away from the courthouse without permission or providing a UA. Or the failure to report violation apparently stems from the failure to appear on September 17 for a scheduled appointment. All right, Mr. Patterson, what are your client's intentions regarding those allegations?
Your Honor, I have discussed the warrant to show cause filed October 1st, 2025 with Mr. Ward, and I can tell the court he is going to waive hearing, stipulate that he has not made any payments until today. Further, he is going to stipulate that he did not provide or submit a random breath, blood, or UA as requested. And then on the addendum to warrant to show cause filed October 31st, he does stipulate that he did fail to report as directed on that occasion.
I paid another payment before that. This is the one I made today. I paid a $300 something payment 2-3 weeks ago, something like that.
All right. Mr. Ward, you're entitled to a due process hearing where the state would have the obligation of proving their allegations by a preponderance of the evidence. You can confront the state's witnesses unless good cause was shown, contest the case if you wanted. And I need to let you know that among other lesser remedies, the court could consider an outright revocation of your probation and ordering you to serve the remaining balance of your sentence locked up. Do you understand these things?
Yes.
Okay. Do you stipulate and agree that you failed to report as directed and failed to submit to a UA in connection with the factual allegations which this court read earlier?
Yes.
Okay. Court finds that the defendant has knowingly waived a due process hearing and rather stipulates and agrees that he committed the failing to report and failing to submit to a UA. Violations would have been alleged by the probation officer who was on the meeting, but now I don't see her. Mandy?
She just exited. I don't know what happened.
Okay.
She's not tried to get back on yet.
All right. Court finds that these are substantial material violations of the terms and conditions of Mr. Ward's probation. So the court will ask for recommendations regarding an appropriate disposition here, beginning with Amber Norris on behalf of the state.
Your Honor, this is defendant's first warrant to show cause. He was initially placed on probation on April 4th for 12 months with court services. Your Honor, based on the allegations and based on recommendations by the court service officer, request 14 days in the county jail. And if he's not able to complete by April 4, he would need to have an extension of his court services probation. And I believe this was originally felony. So I don't know where that falls as far as the court appointed attorney's fees. I know that obviously bids and whatnot was assessed at time of plea and sentencing back in April of 25. But since Mr. Patterson is now on the case as opposed to Mr. Pra, I don't know. So I guess you'll need Mr. Patterson will need to address additional attorney's fees issue.
Very well. Thank you, Ms. Norris. Ms. Moore, is there anything that you would add regarding the appropriate disposition that you're recommending in this case?
I apologize, Your Honor. I lost internet for a minute, so I only heard part of what was addressed.
I'm aware of the recommendation you made in your warrant to show cause paperwork. Has that changed?
No, Your Honor. I did add an addendum on 1031.
We took that up.
Okay.
All right. Very well. Thank you. Mr. Patterson, what are your recommendations regarding an appropriate disposition?
Thank you, Judge. And Judge, first of all, I did want to look at payments just to verify what has been paid, given what my clients told me. I'm looking on the portal. It does show a $350 payment on October 24th. And then it shows a $500 payment November 7th. So those are, of course, subsequent to the warrant to show cause, but still well within his probation term. Judge, from the payments, I think the court can verify that he is employed, and I think his employment is a big concern to him with the recommendations we make to the court here today. His employment is as a contractor, 1099 worker for a firm that has apartment buildings, and he's in charge of these rental properties. And one of the concerns he does have, to be honest, Judge, he just told me about the cold temperatures we're getting ready to have, and that it is one of his obligations to see that tenants' residences are free from freezing up on pipes and stuff like that, it sounds like. So, Judge, we are asked, he's not denying that he violated conditions of probation. He's going to explain to the court about the UA issue. I'll leave that to him to explain to the court. But he's not denying he did violate probation. He's just asking the court to allow him to continue to have his current employment so that he can continue to make payments like he's now made, without losing that. His fear is if he does 14 consecutive days in the Butler County Jail, he's going to get out with no employment, start over, and that'll be it. So, Judge, we would ask the court to consider some type of sanction, such as a 48-hour, 72-hour sanction, but allow him to do that on the warmer weather coming up next weekend versus this weekend, because he really needs to take care of these rental properties and make sure tenants don't get frozen pipes or anything. That is his concern, Judge. Thank you.
Very well, Mr. Patterson. Mr. Ward?
Yes, Your Honor.
Do you have any statements that you wish to make in mitigation of punishment here?
No, yeah, I work for a company that owns 19 different trailer parks.
Okay, slow down.
And,
Slow down.
I said I work for a company that owns like 19 other trailer parks, and I have to. One of my jobs going to make sure the water meters are insulated and everything's ready for government for this cold season. And that's what I was out of town doing. Going around and make sure those are all done and so I do some clean outs. From people getting evicted. And it's a few things, just a few remodels while I was there. But I got the Mitchell Manor Trailer Park here in El Dorado is the last one I got to get done, and there's like 70 trailers there. And I got to get those done before the cold weather hits. So if not, I mean, there's a lot of elderly and disabled people that are could possibly, have water line busts. They can't afford to have people, high water bills and stuff like that. And and if it does bust, I'm pretty sure I'm not going to have a job. So, and this is a good job to have.
Okay, so who pays you?
I work for Blank Family Communities.
Okay, but you don't have a regular schedule?
Yeah, I work. So I've been working 7 days a week here lately. My check's been pretty substantial. But yeah, I got a regular schedule. I go in like 7 o'clock in the morning to dark whenever, sometimes past dark. It depends on what I got going on. If I'm working inside or outside. So.
Anything else you want to say about the violations in this case, or anything else in mitigation here, Mr. Ward?
Yeah, about the UA, I got PTSD from past childhood trauma. And that guy makes me. It's just very uncomfortable. And I guess it's just from that happening. I just panic. It's like I can't help it.
Okay, you were asked to pee into a cup, and that caused PTSD to the extent you had.
It's the way he is. I mean, he's right, he's looking right at you, in your private areas, and it's for past childhood trauma. That sets off a trigger, it's not good.
Well, they wouldn't have to do that if, number one, the probationers didn't often use drugs, and number two, that the probationers often try to cheat the system.
Yeah, that's what Darren was
So, I mean,
saying.
there are reasons why they do what they do. I mean, they're not voyeurs. They don't really want to be doing it anyway. So I just
Yeah.
want to make sure you understand, Mr. Ward, that was never
Yeah.
meant to intimidate you or to scare you or anything else. I appreciate your attempt to explain your situation. Mr. Ward, if you cared enough about your job and the people that you serve enough, I would have thought that you would never pull a stunt like that to run away from a probation officer who's asked you for a UA, and then you sprint away from the judicial center like you don't have to do it and you're not going to do it. PTSD aside, Mr. Ward, you had an obligation that you didn't comply with. And quite frankly, this court is highly offended by what you did. What you were asked for is a very routine thing for a probationer. And then you just decided, for whatever reason, that you just weren't going to do it. And it makes me wonder, what were you going to be positive for if you did do the UA? That's usually why people try to avoid them, because they know they're going to come up positive and they're going to get in further trouble. And if you were going to have a negative UA, Mr. Ward, why not just do it? Instead of thwarting the probation officer who's trying to do a job as ordered by the court and was a condition of your probation. Quite frankly, when I read these allegations today, Mr. Ward, my thought was maybe you're not even amenable to probation. Maybe you should just be revoked and do that year in jail. I mean, just look, probation is the alternative to the incarceration. So either you choose the probation and you're going to comply with it, or you're just choosing to do the time. And I've had some defendants, frankly, just say, I think I'd rather just do the time than do probation. Now, that's not what I'm hearing from you. I think you're wanting another chance here. But
Yes, sir,
after running away from the courthouse, you're a poor risk in this court's view.
Your Honor, I was on probation in Salina and had completed it too prior to this. That's when I got transferred down here.
Did you run away from the Saline County Courthouse too? Or
No, they transferred me down here to Sharon Thiel, and I was on probation for 6 months before I was on probation here in Butler County. I completed that, and I can't complete probation.
This court, quite frankly, agrees with the recommended sanction here, both by the officer and the prosecuting attorney. I'm not going to do an outright revocation here, Mr. Ward, but I am going to order you to start serving 14 consecutive days in the Butler County Jail. However, Mr. Ward, I have a certain sensitivity toward you keeping your job, and particularly the kind of job that you do. If you're really describing your duties accurately, there may be some people that are counting on you to do your job over the course of the next 2 weeks. So this court will grant you 8 hours per day work release. It is going to be in connection with whatever policies and procedures of the Butler County Sheriff's Office and the Butler County Jail. I'm authorizing that up to 8 hours per day. Somebody's going to have to document what your days and hours are.
Okay.
I mean, I trust that you work in the daylight.
Yes, I worked from sunup to sundown, unless I was
You're not going to get up. You're not going to get sun up to sundown.
Yes.
You get 8 working hours a day,
Yes.
and then you work here in El Dorado.
Yes, the Mitchell Manor Trailer Park is where I'm going to be working for this
Okay.
next.
All right, so that's 15 minutes each way. The court would allow you 15 minutes travel time from the jail, plus 8 hours each day that you're authorized to work. But again, it is subject to the sheriff's rules and procedures. But the court will authorize that without extending your jail time. I think that when you get out each day and you do your work in those 8 hours and get back to the jail each night, you'll appreciate the privilege of being on probation even more.
Yes, Your Honor.
but I will order Devin Ward into custody at this time, at the conclusion of this hearing, to start serving that 14 days immediately. Perhaps the jail or the sheriff's office will allow you to make a call to your employer, maybe to set up whatever documentation is needed for the sheriff's office regarding the work release.
Board control, you can, this transfer still here.
8 hours a day, plus 15 minutes travel time to and from.
Okay.
Get those
Thanks,
people
Sean.
taken care of, Mr. Ward. And
All
don't
right.
you ever run from a UA ever again, not in this county.
Okay.
Okay, now, I want direction given to Mr. Ward that he's not going to report while he's on work release. I want him working. So as far as his next reporting requirement, Ms. Moore, what do you suggest he do at the end of this 2-week period?
I'll get out on Thursday, the 20th. If he could come see me Friday, the 21st. Should be
Okay.
the day after he gets out.
Well, he should be getting out on a Friday.
Oh, my days are all mixed up. He could come see me the Monday, the 24th.
Okay.
I would just ask, if he'd rather do a morning or a late afternoon. I don't know what
No,
his
it's
work
just-
schedule is. I didn't know he was working.
Let's just set a time.
Okay.
What time does he have to be there?
You could do an 8:30.
Yes.
Kevin?
Yes.
Okay. All right. You are ordered to report as a condition of your reinstatement on probation Monday, November the 24th at, was it 8:30 a.m.?
Yes, Your Honor.
Okay. You need to be there, Mr. Ward.
Right.
Okay. And I hope you can take full advantage of this work release program without messing up.
Okay.
Since
Thank
the
you,
court's
Your Honor.
giving you the special privilege of work release, the court's going to assess attorney fees, additional attorney fees in the amount of $250 for Mr. Patterson's services, added to any other balance that you might have in the case. Needs to be paid before you get off probation, Mr. Ward.
Okay.
And do we need to look at extending at all?
Your Honor, he's on till April. So probably not.
I would agree. I don't. Court services can seek a extension at that time if they think one's warranted under the circumstances. But I hope you complete during the original probation period, Mr. Ward, and I hope we don't have to review your sentence again.
Okay. Thanks, Your Honor.
All right. Mr. Patterson, is there anything further we need to address here?
No, Your Honor.
Ms. Norris?
No, Your Honor, thank you.
Ms. Moore?
No, Your Honor.
Most importantly, Mr. Ward, do you have any questions about what we've done here?
No, Your Honor.
Okay. All right, then I'm ordering him into custody to start serving his 14-day sanction period subject to the work release order, which the court has made earlier. Ms. Norris, that would appear to conclude the docket, but Mr. Patterson, hang on.
It does as far as I can tell, Judge. Thank you.
All right, that will conclude the docket. I can release all participants except Mr. Patterson.
it.